It is February 2025. I'm Robert King, the owner of King Law. I'm going to give you the updates for the biggest multi-district litigations, federal court lawsuits that we're working on right now. These are the most recent updates that I have. If you stick around to the end of the video, I'll tell you how you can follow us more regularly and get the updates as they come out on a weekly basis.
Many updates on our mass tort cases.
Yeah, February 10th, 2025. We've been working on a whole bunch of mass torts. Bunch of updates. Let's just burn through all the big cases we're looking at.
Let's talk about PFAS. What's going on?
PFAS is huge. Municipality PFAS settlement occurred for the drinking water providers almost 2 years ago now. The process of handing out about $14 billion to these water suppliers has taken a long time. It got a little bit delayed at the end of 2024. We got emails last week that the data has been finalized, and I would expect municipalities to start receiving money for the water contamination portion of the PFAS settlement sometime this spring. So probably April. But what that really is doing is the focus has now shifted to the personal injury PFAS claims, whether it's AFFF, firefighting foam direct exposure, or drinking water exposure, exposure on military bases. Those personal injury claims, the most serious of which are kidney and testicular cancer, but also thyroid cancer, thyroid disease, ulcerative colitis. Those are the injury cases that we're looking at, and I would expect those to really progress this year, and then see a focus at that point shifting onto wastewater, sewage treatment plants, as well as land contamination, specifically airports, fire training centers where the firefighting foam was used. Some of the ground is very contaminated, and I think we're going to work towards getting some of that cleaned up over the course of the next few years.
So what I think I heard you say was the municipalities, the phase one, in the sense of just the drinking water, has been settled, and settlements will be distributed sometime in the spring.
Yep, phase one money should be going out in the spring, early summer. That's what we're hearing right now. And then phase two has until the end of this year. So the municipalities that didn't have a positive test prior to the date of settlement in June of 2023. Okay. So we're in the process of submitting the phase two municipal claims, and then we're working on the personal injury claims at the same time.
At the same time. Okay. Thank you for clarifying that.
All right.
The next one let's talk about is Suboxone.
Suboxone is a huge case that a lot of people don't know about. The craziest part about Suboxone is the CEO of Suboxone went to jail.
What?
This is a company that had some very, what they would say, aggressive marketing tactics, and which Department of Justice has said was illegal. The whole backstory of Suboxone is Suboxone was used to treat opioid addiction, both heroin and prescription-based opioids, and Suboxone comes out in pill form. The company didn't want to lose the patent protection, so they went through this whole crazy rigmarole to get the pills off the market and start using the films, the Suboxone films. So the cases we're taking are these Suboxone film cases. It causes tremendous tooth damage. There are many, many cases out there. We've signed thousands of Suboxone cases. Almost all the people have lost most or all of their teeth. The deadline for Suboxone is coming up quickly. There was a warning eventually put on to the box. So that's gonna create a deadline. That deadline is fast approaching, depending on the state where you lived.
So what does that mean, deadline? Deadline in the sense of the time frame that you used it, or the time frame that you can file a claim?
The time frame you can file a claim. Okay. So we're looking for people who actually use Suboxone, not generic Suboxone, and then had an injury within a certain time frame. And in each state is different. We're taking cases in all 50 states, but the statute of limitation is different, and we need enough time to order the records, review the records, and file the claim before the statute of limitation is up. So this is something that we have a big push on Suboxone. We're working really hard to get the kind of word out for the people who have been affected in the Suboxone cases. So that's a big push for us here, actually, over the course of the next week or two.
What is the eligibility for Suboxone?
You used Suboxone and you lost teeth. That's it has to be actual Suboxone, not generic. Depending on the date of use, earlier will be almost all Suboxone, and then when generic comes out, the majority of the use will go to generic.
And it's just film, right?
Only the films,
Yeah.
not the pills.
Okay. Let's jump into Depo-Provera.
Depo-Provera is an MDL. All the cases in the United States got consolidated last week. They're going to Florida. Plaintiffs wanted California. Defense wanted New York. The JPML, I don't know if they split the difference and sent the case to Florida. It's Judge Rogers. Judge Rogers was the judge in the 3M earplug case, a huge settlement, very complex case. I think this is a really good development for plaintiffs. I think it makes me personally much more interested in the case because very complex, big defendant, Pfizer subsidiaries, they're going to be super well-funded defense, and you have a very experienced judge who will be able to keep the case moving. And that's what you want as a plaintiff's lawyer. So
this is a positive,
This
right?
is a positive.
Yeah.
This is a positive, in my opinion. That's, other plaintiff's lawyers may tell you otherwise. I think they really wanted California because of a thing called innovator liability. And I think innovator liability is still going to be there.
What does that mean?
It means, so there's a theory of law that says generally people who make generic drugs cannot be held legally accountable because they just copied what the original drug company did, in this case, Pfizer. There's a couple nuances in the Depo-Provera MDL without getting super into the weeds. These are authorized generics. They're the exact same, and they're actually manufactured by companies that are partially or completely owned by Pfizer. But there's a question of, if somebody takes a generic, can you sue the innovator, in this case Pfizer? And the law on that issue is strongest in the state of California.
Gotcha.
So what will be argued now is the federal court judge in the state of Florida should apply California law,
Okay.
which makes it a little bit more confusing. So there's all these other states, but how that plays out is
Because
not...
the generic is owned by the parent company?
In this case, that's the allegation.
Okay.
But the idea in general is a generic drug company copies what the original drug manufacturer did. So if they broke the rules and then the generic copied them, a person who took the generic should still be able to sue the original developer of the drug. And that is a theory that is not accepted throughout the whole United States. It's accepted in some places and not others.
Okay. All right. Well, we'll keep you updated on that.
So we would expect Depo-Provera. We will see who is going to lead the litigation. We'll get a timeline, and I would expect later in this year there will be documents between the plaintiffs and the defense start getting exchanged, and we'll know more. It's going to be a very exciting year for the Depo-Provera litigation.
And next topic is, I would feel like our most well-known drug or mass tort case, which is Ozempic.
Ozempic.
Let's talk about that update.
Yep. Ozempic, Novo Nordisk manufacturer. Then you have Eli Lilly, who's making Mounjaro. Huge litigation. The MDL is in the Eastern District of Pennsylvania. RFK has been speaking against Novo Nordisk a whole bunch. There's a great question of whether we should accept kind of the idea of what Novo Nordisk is saying. And generally what they're saying is obesity needs to be treated with injection or pill form. That's different than what the general prognosis or way to treat weight loss, diabetes has been treated for the last long time. There's also increasing studies of all these other problems caused or correlated to GLP-1 use. And I think the one that strikes home for me is the vision loss.
Yes.
No one who takes GLP-1s is expecting to go wake up in the morning and go blind.
Right. No.
More warnings coming out about it. I think there's more being learned about it. It's a huge litigation. There's going to be aggressive briefing on what the warnings do or do not allow plaintiffs to sue for. And there will be some major developments over the course of the next 90 to 120 days from the judge in that case.
And there's two, correct me if I'm wrong, but my understanding is there's 2 points to this lawsuit. One is the labeling, and then the other is the severe side effects.
There's definitely different parts of this lawsuit. There was also a decision from the judicial panel for multi-district litigation which said DVTs and vision loss are not part of the MDL right now. They're not. So the original federal court lawsuit is largely centered around gastroparesis, bowel obstruction, ileus, certain gastrointestinal injuries, and a few other things. But there was an application to add some additional injuries, and that application was denied. So where these other injuries will go, will it be in state court? Will it be in New Jersey state court, where the Novo Nordisk North American headquarters are? That's certainly a possibility. Will there be a different multi-district litigation for these injuries? That's out there. Separate than that, what the defendants have said is, we said that GLP-1s can cause gastrointestinal problems. So you can't sue us. You're preempted. The big word you'll hear is preemption. And I guess what the plaintiffs will say is, the warning wasn't clear enough. It wasn't specific enough. Saying you can have gastrointestinal problems is a little different than saying
you're going to be in the ICU for 3 weeks because your stomach is paralyzed.
There can be permanent and life-altering injuries. I think the warning, and you're looking at some different drugs, so the warnings do say a few different things, but they say they generally improve over time. There's some great questions in this lawsuit, too, about what is allowed as far as marketing. What Novo Nordisk is marketing very aggressively. They're using influencers. They're not telling people that it's drug marketing. That's going to be front and center throughout this litigation, and really looking forward to see how the judges come down on that particular issue as well.
All right. Camp Lejeune.
Camp Lejeune.
Some
huge lawsuit.
Yes.
Very slow to get started. Has progressed relatively quickly. You have 35 years worth of documents. Over 500,000 people filed claim forms. Tremendous amount of discovery. And what you see in these monthly court appearances in the Eastern District of North Carolina is really, on paper, they seem kind of nitpicky, but how are we going to get these documents? So the government has 35 years worth of microfiche or pieces of paper. How do we go about scanning those and getting them to the plaintiffs in anticipation of trials? Everybody wants to have trials. That's what's going to drive a settlement, but you also have to understand what's going on in all the cases. And right now we're down to 25 potential first plaintiffs to go to court. We represent one of those people, so that's been really interesting. All the witnesses. Another thing that's people are arguing about is how long the government's experts are allowed to physically examine the 25 plaintiffs. The government's asked for 4 hours. We all know that most doctors don't examine people for 4 hours, but at the same time, these are critically important cases. I don't think anyone is saying you shouldn't have time to examine the people. They're very badly injured, go through their records, but 4 hours seems a little extreme to me. But that's the request of the government.
All right. So the next one would be video games.
Video game addiction. Video game addiction is going to be an up-and-coming lawsuit. It's really using some of the neuroscience and science against children. That's the allegation that these companies, whether they are owned by Microsoft, so Activision Blizzard is ultimately owned by Microsoft. They produce certain games. Another game, and I think the biggest one that we're looking into is Roblox, targeted at really young children.
Yeah, what's an age range for that? Is there one?
I think it's really targeted under 15 years old, but you see a lot of the folks that we're representing are between 6 and 12 years old, and the companies using things that are known to addict people, whether it's random reward, whether it's type of dopamine hits. They're specifically designing the games to get kids to use them and spend their parents' monies. They're not warning of the dangers. There's all sorts of.
It's similar to like a gambling addiction in a way.
And I think what the allegation from plaintiffs' lawyers is they specifically created these things to trigger those responses in very young children, and that doesn't feel right to people. There are lawsuits being filed throughout the United States, specifically the state of California. Roblox is centered in California. There's a whole bunch of people in the state of California, so I think some early lawsuits are being filed against Roblox. I think that litigation will continue to grow, something that we're looking at really carefully.
What's the eligibility as of right now for for this lawsuit?
Yeah, it's like 15 hours of gameplay per week for every week for, depending on the age of the person, 6 to 12 months, and then objective manifestation of this addiction, whether it's acting out at school, getting arrested, physical
signs of addiction,
self-harm, threats of self-harm, something that's a noticeable change in a young child.
And lastly, let's talk about hernia mesh.
Yep, hernia mesh. And hernia mesh is really two different cases at this point. So
what do you mean by that?
Bard hernia mesh. The two biggest manufacturers of hernia mesh are Covidien and Bard. The Bard case has mostly settled. The cases up to a particular date have settled. The first 33,000 cases have a settlement offer. And then Covidien is a different manufacturer of hernia mesh. It's a completely different lawsuit. That's one that we're working towards dates for a bellwether trial. That's a different case, but I would say, depending on the year, 50, 60, 65% of hernia mesh is manufactured by Bard. The cases that come in now are not part of the settlement, but we anticipate that they will be part of kind of a phase 2 or round 2 of the settlement. And then Covidien cases, we think we'll get a trial maybe in a year, and you could get a settlement before or after a bellwether trial. So we're working on those cases as well. But we're working really hard to go through our inventory of old cases and find where people will fit into the Bard settlement. That's what we're working on every day right here in the office.
So when you talk about settlement, because I think most people hear settlement and they're like, oh my gosh, I'm going to get money in like a week. But that's really not the reality. Can you kind of explain that? Yeah,
great question. So the Bard settlement is $1.3 billion minimum, and that goes to the first 33,000 people who filed cases into either the federal court multi-district litigation or the Rhode Island state court litigation. So handing out, like to say it in a short way, it takes a while to hand out $1.3 billion. The idea is that there is a settlement matrix, and you have to figure out how many of each people there are and divide that money up. So it's not like a car accident case where you reach a settlement and you're going to get $100,000. You sign the release, 2 weeks later you get the check. This is a little different than that, and that's because you're dealing with thousands of people at once. And while it feels inefficient for any individual, the fact that you can settle 33,000 cases at a time is a minor miracle. So altogether, the group of people, it's relatively efficient. It's been a long time coming. Several years of litigation, and administering the settlement will take well over a year itself till you get any money, but I would say it's better than the alternative, which is not being compensated for the injuries that you've suffered.
Right. And this is a case where you base the settlements off of the injury, or because it's not just like one that you file and everyone gets the same amount across the board?
Yeah, that would be like a class action if everybody got the exact same. So you're looking at a couple different things. Some products are deemed to be more risky than others, and then different injuries. So a person who has some minor adhesions around the hernia mesh, they may be entitled to a recovery, but not the same if the adhesion had gone into the bowel and they had to have major reconstructive intestinal surgery.
Right.
That person's going to get more money.
Yes.
And then depending on what product, if it's a product where we can prove the company really knew about the risk, maybe Kugel mesh, that person can get more money than a different type of mesh. And it
just varies.
It varies. It's complicated, but whatever it is, I think if somebody suffered, they should certainly look into that.
Yeah. Well, thanks for updating us. We'll keep you updated as we get updated and go from there.
That's a big one. Those are the updates for the biggest federal court lawsuits that we're working on here today. We're also involved in a total of about 25 different multi-district litigations and federal court lawsuits. Be sure to like and subscribe. You can follow us on social media. You can also check out our website, robertkinglawfirm.com. We try to update the pages as we get updates in the case. So we're updating these on a weekly or bi-weekly basis, and be sure to check back on those platforms and right here on YouTube as well.